Professional responsibility rules. In order to have an effective attorney-client relationship, particularly when dealing with business associations, identification of the client is critical. The fact pattern is unclear as to the identity of the client. The potential clients are 1. Ellen individually, 2. Nonprofit incorporated, and 3. Both. Corporation as client. Importantly, a lawyer representing a corporation does not represent that corporation's employees, including senior officers, and even if there is only one employee. The corporation is a distinct legal entity entitled to independent and zealous counsel. Written agreement for fees. The ABA does not require written fee agreements. If Linda was receiving a fee and more than $1,000, she might have violated the California rule requiring such agreements to be in writing if not for the fact that nonprofit is a corporation, because that is an exception to the rule on written fee agreements. Other inapplicable exceptions include when the client in writing says it does not want a written fee agreement, or there is a prior relationship, and an exigent circumstance arises requiring prompt action by the lawyer to protect the client's interests. It would have required the fee agreement in writing as to Linda if over $1,000, or 2. Improper payment of legal expenses by a third party, without taking adequate precautions to ensure independent representation and preservation of confidentiality. Joint representation, potential conflict, waiver of conflict. It is an improper dual representation of clients with actually conflicting interests in the absence of an effective disclosure and consent. The ABA rules apply a reasonable lawyer standard that prohibits representing actually conflicting clients unless the lawyer reasonably believes that it will not materially impair their ability to perform the required legal services competently and diligently. That conflict waiver must be confirmed in writing by both clients affected by the joint representation after receiving complete disclosure of the risks from the lawyer. In California, there is no reasonable lawyer standard. The rule applies to both potential and actual conflicts. In case of conflicts between clients, as here, the disclosure must be in writing as well as the client's consent to it, and in case of personal and professional conflicts, the disclosure must be in writing. With respect to the employment agreement, Linda was obligated to zealously and competently represent nonprofits' interests. The fact that Ellen drafted the employment agreement is not necessarily unethical in and of itself. A lawyer is entitled to rely on their employees and independent contractors to perform services subject to their supervision. A lawyer can also allow a client, or in this case, the employee of a client, to prepare documents so long as the lawyer exercises diligent and competent review and independent legal judgment in rendering advice. A lawyer has the duty to communicate with the client, and where, as here, the only employee is in an adverse position, the board represents the interests of the corporation. Privileged communication. Linda is also required to inform that board that it cannot have a privileged conversation with her about the employment agreement if Ellen is present. Accordingly, Linda should probably recommend that the board chair retract his invitation to Ellen, or at the very least ensure at the outset of the meeting that they all understand that there will be no privilege between them. Client communication. The duty to communicate includes the duty of candor and honesty to the client. Attorney-client relationship. Organizational client. When a lawyer is hired to represent a corporation or organization, the lawyer's fiduciary duties are to the organization and not to the individual members, directors, or officers. A lawyer has a duty to act on the best interests of the organization and can, therefore, not engage in conduct which would benefit any individual or group of individuals at the expense of the organization. Fee agreement. Under ABA, a lawyer who agrees to represent a client must not put the agreement in writing, unless it is for contingency fees. However, California rules of professional conduct mandate that lawyers must put the agreement in writing if it is over $1,000. However, when the client is an organization, or a repeat client, or if there is an emergency, a lawyer does not have to write up the agreement. Duty of loyalty. A lawyer owes her client a duty of loyalty, which includes the duty to avoid a conflict of interest. A conflict can arise where the lawyer knows that her client's interest will be materially adverse to that of the lawyer's own interest, or another client. When such a conflict arises, a lawyer might still be allowed to represent the clients so long as there is no claim by one client against the other. Such representation is not prohibited by law, and the lawyer's lawyer gets the informed written consent of both clients. California also allows a lawyer who has a potential conflict of interest to continue to represent the clients so long as there is informed written consent. Duty of diligence. Under both ABA and CA, a lawyer has to promptly, adequately, and zealously represent her client. Duty to report, loyalty. When a lawyer represents an organization and learns of conduct made by an individual in the corporation, which materially harms the organization in terms of financial harm or even reputation harm, the lawyer has a duty to report up. Under ABA, the lawyer has to first report the individual's conduct up to a higher authority in the company, such as the board of directors. If the board does not do anything to remedy the harm, the lawyer has to report to a relevant authority outside of the corporation. CA rules differ slightly. Under CRPC, a lawyer has the duty to first report up the chain to the board of directors, for example. If the board fails to act, the lawyer may not report out, but rather should seek withdrawal. Duty to communicate. Under both ABA and CA rules, a lawyer has a duty to communicate important material matters regarding the representation to her client. Hiring and use of Kelly's services. Under both the ABA and California rules, a lawyer may not assist another in the unauthorized practice of law. This rule extends to the hiring and employment of disbarred attorneys. Hiring of Kelly. A lawyer may employ a disbarred lawyer as a clerk or paralegal to assist in certain activities that do not involve the practice of law. However, the lawyer must take care to prevent the disbarred attorney from conducting activities that constitute the unauthorized practice of law. For example, a disbarred attorney can conduct research, draft documents reviewed and supervised by the lawyer, and conduct other administrative tasks such as communicating with the client concerning billing. The disbarred lawyer may not engage in counseling of the client, appear before any tribunal, or communicate with the client or adversaries concerning substantive matters that constitute the practice of law. However, under the California rules, where a lawyer retains a disbarred attorney as an employee, the lawyer must notify the state bar of the employment, as well as the client. California rules depending on the level of supervision and management by hand, similar to the drafting of the counterclaim. A lawyer may use a non-lawyer, including a disbarred lawyer, to draft documents and conduct research. However, the disbarred lawyer may not engage in activities that constitute the practice of law. Drafting deposition questions requires legal skill and judgment, and would likely constitute the unauthorized practice of law unless and merely used Kelly's work for reference and supervised and edited her work. Depositions are typically limited to counsel, the witness, and the court reporter. The parties also typically make their appearance on the record, and the opposing side would have understood Kelly to be second-chairing the deposition on the facts. Therefore, Kelly's appearance at and passing of notes to and during the deposition likely constituted an ethical violation. Filing of a frivolous counterclaim. A lawyer may not assert a legal claim for the purpose of harassing another party or gaining an unfair litigation advantage. Under California rules, a lawyer may not threaten to report another person for disciplinary purposes in order to gain an advantage in a litigation. Where the lawyer has a good faith belief that a violation has occurred, the lawyer may advise the party that they might file a complaint. But the lawyer must not do so in order to gain a litigation advantage. Duty to the tribunal. A lawyer must not counsel a client to violate a court order. Although and could have counseled player to push back on his contractual obligations if she had a good faith basis for doing so, here the court had imposed a preliminary injunction requiring player to perform under the contract. Thus, and directly advised her client to violate the court order without any good faith basis for doing so. Duty of competence. In addition to breaching her duty to the tribunal, this likely constituted a breach of her duty of competence owed to player, because a reasonably prudent lawyer would not counsel their client to disregard a court order that is likely to subject them to contempt charges. Disbarred attorney/resigning. A disbarred attorney must resign from their law firm and cannot associate with that firm as an attorney. Employing disbarred attorney. In CA, a disbarred attorney can be hired to work as a litigation support clerk or in a similar support. The disbarred attorney can only work in this limited capacity. Moreover, the CA state bar must be notified if an attorney seeks to hire a disbarred attorney. Additionally, the disbarred attorney is prohibited from interacting with clients in a manner that would reasonably lead the client to believe the disbarred attorney was an attorney. Therefore, their client contact must be minimal. Telling client to ignore court order. A lawyer has a duty to the court and the profession to act with integrity, in good faith, and ethically. Failure to do is a violation of both the CA and ABA RPC. Duty of competence. A lawyer also has a duty of competence. A lawyer must act with the knowledge and skill reasonably necessary to provide competent and diligent legal services. Under the ABA, the standard for a breach of this duty is reasonableness. In CA, a lawyer breaches their duty of competence if they act intentionally, recklessly, or with gross negligence. Frivolous legal action. A lawyer must not threaten to bring an administrative complaint against a lawyer or non-lawyer absent a good faith basis for filing the complaint. It is unethical to threaten or pursue such a complaint purely for the purposes of harassing the subject of the complaint. In other words, they must have a reasonable belief in the merits of the claim, and they must be pursuing the litigation for a legitimate basis, i.e., remedying a legal right, and not to harass. Duty to supervise. A lawyer may delegate tasks to their non-lawyer employees. However, the lawyer must closely supervise the non-lawyer's work, and the lawyer remains ultimately responsible for the work product. An attorney owes his clients the duty of loyalty, confidentiality, competence, and financial responsibility. A lawyer also owes third parties, the public, and the court the duties of fairness, dignity, and candor. Associate lawyer following the supervising partner. A lawyer owes the duty to supervise attorneys and staff that work under the lawyer and ensure they do not commit any ethical violations. A lawyer who is being supervised still must follow the ethical rules despite being told otherwise from supervising attorneys. If there is an arguable question of law/duty regarding the ethical violation, then the lawyer may rely on supervising attorneys for advice and instruction. If there is no questionable issue of law or duty, the attorney must adhere to the ethical rules of the ABA and California, even if it goes against what the partner says. If the attorney violates the rules, both the associate lawyer and the partner will have committed ethical violations. Duty of competence. The duty of competence requires an attorney to act with the legal knowledge and skill necessary to perform for the client. In California, the duty of competence is looked at under a reckless standard. A lawyer will not violate the rules for a single issue that breaches the duty of competence. Duty of loyalty. The duty of loyalty requires an attorney to act with the legal skill and knowledge necessary to represent the client. If the area of law is unfamiliar to the attorney, they have a duty to familiarize themselves with the area of law in order to adequately represent the client. Though Larry is an associate, he still must familiarize himself with trade secret law in order to competently represent Jones, or must associate with a lawyer who has sufficient experience in trade secret law. Duty of competency requires attorneys to fight zealously for their clients. It does not allow an attorney to assert false, misleading, or frivolous defenses. Duty of fairness. A lawyer owes a duty of fairness, dignity, and candor to the court and opposing party. Simultaneously, a lawyer owes the duty of confidentiality and loyalty to their client. A lawyer has a duty to follow court orders, including discovery request, and to not assert frivolous litigation claims or defenses. Duty report violations of other lawyers. The issue here is whether Larry must report Peter's ethical violation to the bar. The ABA rules require that an attorney report any ethical violations of another attorney or judge to the bar. California does not follow the same rule, so Larry will not need to report Peter's violations to the California bar. However, California has a duty to self-report violations, malpractice claims, or other ethical violations/cases that may arise. Larry may need to self-report if he commits any ethical violations under California rules. Conflict of interest. Duty of loyalty. A lawyer owes their current clients the duty of loyalty. A conflict of interest may give rise to breaching the duty of loyalty. A conflict of interest exists when a lawyer represents two clients in the same suit as adverse parties, or when there is a significant risk that the lawyer's personal life, duties to current clients, or duties to former clients may materially limit the attorney's ability to act in the best interests of his client. If there is a conflict of interest, an attorney may still represent the client if the attorney reasonably believes he can still represent the client without breaching any duties and acting in the client's best interests, and the client is aware of the conflict and gives informed, written consent. The attorney cannot represent the adverse clients in the same case in a tribunal, and the representation cannot be prohibited by law. In California, the client's consent must be in writing. Conflict of interest. If Larry does not reasonably believe that he can continue representing Jones due to the job offer, even if he does not take the job offer, then he must cease representing Jones and allow another attorney at his firm to take over the case. He will likely need to be screened off from the case and not share in a portion of fees earned from the Jones v. Smith case. In California, an attorney must disclose, in writing, to his client any personal relationship the attorney may have with another party, witness, or lawyer in the case. Conflict of interest duties to former clients. If Larry leaves ABC and goes to XYZ, he will now be adverse to former client Jones and ABC. This gives rise to a conflict of interest. A lawyer owes the continuing duty of confidentiality to former clients. A lawyer's conflict may be imputed to the firm if it is not personal in interest. If Larry took the job, Larry's conflict with Jones at his new firm XYZ would not be personal, and would therefore be imputed to the firm since he worked significantly and substantially on the case Jones v. Smith. Larry has learned significant confidential information from Jones about the case. If Larry were to go to XYZ, then he must be screened off from the case, not share in any fees earned from the case, and XYZ must give notice to ABC. Associate attorney's duties with regard to following a supervising attorney's instructions. Under both the ABA Model Rules, MR, and the California Rules of Professional Conduct, RPC, an attorney that is working under the supervision of a partner or other attorney has a duty to abide by the instructions that the supervising attorney gives, while still maintaining her duty to maintain independent professional judgment and to avoid committing a clear ethical violation. If the reasonable minds of attorneys would differ as to whether the action ordered by the supervising attorney would constitute a violation of an ethical duty, then the attorney must abide by the supervising attorney's instructions and will not be liable for an ethics violation. If no reasonable minds would differ as to the propriety of an action, or if it is clearly a request for a violation of an ethical rule or law, then the associate attorney must refuse to take the action. Duty to avoid frivolous claims. Under both the MR and the RPC, an attorney must not bring a cause of action or claim that has no basis in law or fact, or where the attorney has no good faith argument for an extension of existing law or a change in existing law. Duty to report ethical violations. Under the MR, an attorney has a duty to report any ethical violations that they know another attorney has committed. The RPC does not have a corresponding duty to report ethical violations of others, but it does impose a duty on attorneys to self-report when they know that they have committed ethical violations. Duty of confidentiality. Generally speaking, under both the MR and the CA, an attorney must not disclose any information relating to the representation of a client unless authorized by the express written consent, informed written consent in CA, informed consent confirmed in writing under the MR, or unless impliedly authorized in order to carry out the representation. Duty of diligence. Under both the MR and CA RPC, an attorney owes a client a duty to provide reasonably diligent and prompt representation. Under the RPC, an attorney must be committed and dedicated to their client's cause. However, this duty does not require an attorney to press for every available advantage. And as discussed below, an attorney must not violate the duty of fairness in an effort to zealously advocate for their client. Duty of fairness. The duty of fairness requires that an attorney act with fairness to opposing counsel during the courts of litigation. This requires that an attorney not knowingly obstruct another party's access to evidence, nor alter, conceal, or destroy evidence or counsel, or instruct another to obstruct access to evidence or conceal, alter, or destroy evidence in the course of litigation. Larry's ethical obligations with regard to XYZ's job offer. Duty of loyalty. Under both the MR and the RPC, an attorney owes all clients, past and present, a duty of loyalty and independent professional judgment. When there is a substantial risk that the attorney's representation will be materially limited due to their own interests, or the interests of past or present clients, then a conflict of interest may exist that could hinder the attorney's ability to provide competent and diligent representation. If a conflict of interest exists, then the attorney may be in breach of their duty of loyalty. Duties of loyalty and confidentiality of past clients. An attorney owes continuing duties of both loyalty and confidentiality to past clients, even after the representation of those clients has ceased. The duty of confidentiality to past clients means that an attorney may not reveal information relating to the representation of that client, regardless of the source, unless authorized by the express written consent of the client. The duty of loyalty to past clients means that the attorney may not participate in an action against that client, or use information relating to the representation of the client, unless under the MR, the client provides informed consent confirmed in writing, or under the CARPC, the client provides informed written consent. Informed written consent/informed consent confirmed in writing. Note: while informed consent confirmed in writing, ABA, only requires an attorney give full disclosure orally before the client provides written notice of consent, informed written consent, CA, requires that the disclosure of the conflict is in writing, and the client's consent is also in writing. Conflict of interest when moving to new firms: past and present client conflicts. Under both the MR and the RPC, where an attorney has worked on the same or substantially similar matter for one client, and then moves to a new firm that is working on the same or substantially similar matter for the adverse party of that representation, a conflict of interest exists. That conflict of interest is imputed onto the other attorneys in the firm, and the firm must not take on the case, regardless of who works on it, unless 1. The former client gives informed written consent, under CA, or informed consent confirmed in writing, under the MR, or 2. The new attorney is properly screened. Screening procedure. An alternative for the firm exists where the new attorney is properly screened. This requires that the new attorney with the conflict does not work on the case in any way, does not have access to the case files nor discuss the case with any of the parties working on the case, and is not apportioned any fee for that case. Additionally, the firm must provide notice of the decision to screen, and the screening procedures put in place to the former client, and must certify compliance with those screening procedures if requested by the former client. California exception for personal and substantial work. Under the CARPC, a new lawyer's conflict is imputed into the entire firm, and the entire firm may not take on or continue a case, even with appropriate screening procedures or informed written consent, if the new and conflicted attorney worked substantially and personally on the same matter for the other client. Duty of candor, duty to disclose, duty to correct false witness testimony. Under both the ABA and California Ethics Code, CA rules, a lawyer, as an officer of the court, has a duty of candor. Under both the ABA and CA rules, a lawyer also has a duty to disclose law that is contrary to the client's position. However, a lawyer is not required to disclose facts that are not helpful to the client. Moreover, a lawyer must not offer evidence that he knows to be false or misleading, and must seek to rectify any false evidence presented. If a lawyer reasonably believes that a witness will testify falsely, the lawyer must try to convince the witness or client not to testify falsely. If that fails, the lawyer must not allow the witness or client to testify. Under ABA and CA rules, a lawyer may then seek to withdraw. If a witness or client does testify falsely, in addition to seeking to rectify the false evidence, under the ABA rules the lawyer may notify the court or appropriate tribunal. Retaining an expert. Finally, under both ABA and CA rules, when retaining an expert, a lawyer is required to get the client's informed consent, which must be in writing under the CA rules, which includes a clear statement of how the expert is going to be paid. The client is to be fully informed as to the terms of the retainer of an expert before the expert is, in fact, retained. Duty of candor to the court and opposing counsel. Under both the ABA and CA ethics rules, attorneys own a duty of candor and truthfulness to both the court and to opposing counsel. This means that, while an attorney is required to zealously advocate for the interests of their clients, they may not introduce testimony which they know to be false. 2. Attorney as a witness. Liu also violated his ethical duties when he effectively served as a witness in this case. Under the ABA rules, an attorney is not permitted to act as a witness in a case which they are litigating unless their testimony, 1. Relates to a non-disputed issue, or 2. The attorney is so critical to the case that they cannot be removed as counsel, and their testimony is critical. Duty of competence. Liu also may have violated his duty of competence. Under the ABA rules, an attorney must carry out a representation in a competent manner. Under the CA rules, an attorney must not repeatedly carry out a representation in a negligent, reckless, or incompetent manner. Duty of loyalty. The first issue is L's breaches of the duty of loyalty. A lawyer has a duty to act in the best interests of their client, which means avoiding potential and actual conflicts of interest. Potential conflicts of interest. Under the ABA and CA rules, an attorney may represent two clients with a potential conflict of interest if he, 1. Reasonably believes that the representation of either client, the lawyer's own personal interests, or the interests of his family will not materially limit his duties to the other, 2. Informs the client in understandable language of the conflict, and 3. Obtains written consent. Under the CA rules, the belief that representation won't be materially limited doesn't have to be objectively reasonable. It can be subjectively reasonable based on what the attorney knew. So under the ABA rules, an attorney must advise a client of any conflict of interest and obtain consent, memorialized in writing, if the client consent was initially oral. CA requires written consent to all conflicts of interest. Additionally, CA requires the lawyer to advise on all potential and actual conflicts and obtain additional consent if a conflict actualizes. Actual conflicts of interest. An actual conflict of interest is treated under the same standard as above. But under the CA rules, an attorney just needs to advise a client of a personal conflict in writing. They don't need written consent. Attorney-client privilege, joint representation. When an attorney represents co-clients, attorney-client privilege and confidentiality is waived as between them. An attorney may represent co-defendants, but must advise them of the risk from losing confidentiality and obtain written consent. Improper Fee Agreement. The ABA prohibits contingent fees in criminal and domestic cases. CA prohibits contingent fees in criminal cases, or in a domestic case where the contingent fee promotes the dissolution of a savable marriage. A contingent fee is a fee where payment depends on the outcome. Usually the lawyer is only paid upon the resolution of a favorable result. Retainer. CA requires all fee agreements to be in writing, unless the client is a corporation, the fee is less than $1,000, or the fee is for routine work for a regular client. Contingent fee. Next, both the ABA and CA require certain information in a contingent fee arrangement. The ABA requires the attorney's percentage of recovery, whether it's taken out before or after expenses, and who pays for which expenses. CA also requires the lawyer to advise the client how work not paid for under the contingency will be compensated. Excessive fee. Under the ABA rules, a lawyer's fee must be reasonable in light of the experience of the lawyer, time and preparation required, nature of the case, and the result achieved. Under the CA rules, the fee must not be unconscionable. Duty of competence. A lawyer has an obligation to competently represent his clients. Under the ABA rules, a client must employ the time, preparation, skill, expertise, knowledge, and experience necessary to reasonably represent the client. If a client does not have those factors, he must learn the relevant material if possible without undue delay or associate with a competent attorney. CA looks to a similar standard, but will only discipline a lawyer for repeated or reckless violations of the duty of competence. Duty of loyalty. A lawyer has a duty of loyalty to his clients. The duty of loyalty prohibits a lawyer from representing an individual with interests that are adverse to that of a current or former client. A lawyer may nevertheless represent parties with conflicting interests if he reasonably believes that he can provide adequate representation despite the conflict, if he can inform both clients of the conflict without breaching his duty of confidentiality, and if he obtains the consent of both clients to proceed. In California, the lawyer needs only a subjective belief that he can provide adequate representation. Additionally, California requires that the lawyer obtain written consent from the clients. Moreover, the California rules require a lawyer to get the consent of the clients when the potential is merely a potential conflict, and again when the conflict ripens into an existing conflict. Personal conflicts of interest. The duty of loyalty also requires that the lawyer disclose his clients of personal conflicts that he has. In California, personal conflicts simply require disclosure and not consent, and personal conflicts are not imputed to other lawyers at the attorney's firm. Lose retainer agreement. The facts here indicate that L will make every effort to inform clients of potentially conflicting representations. This disclaimer is not enough to satisfy the consent requirement for a conflict of interest and does not relieve Lou of any liability for not receiving consent for conflicts of interest. This disclaimer has no effect on Lou's duty of loyalty to Betty and Sheila. According to the CA rules, this is not sufficient, and Lou must obtain written consent from the clients for any potential conflicts of interest. Duty of competence. A lawyer has a duty of competence which requires him to provide competent representation to his clients by using the appropriate skills, knowledge, and thoroughness. A lawyer who is not competent in a particular area may nevertheless take a case in that area if he can either 1. Become competent before trial through research and familiarizing himself with the area of law, or 2. Associating with a lawyer who is competent in the area. Additionally, in an emergency, a lawyer may act in an area in which he is not competent, as long as he stops the representation when the emergency is over. In California, a lawyer breaches his duty of competence only if he intentionally, recklessly, or repeatedly acts without competence. Fee agreement. Contingent fees. In a contingent case, the lawyer must give the client a written fee agreement that states 1. The lawyer's percent of the recovery, 2. Expenses to be paid out of the recovery, 3. Whether the lawyer's fee will be taken before or after expenses are taken out, 4. Other expenses that the client will be required to pay. Additionally, under both the ABA and CA rules, contingent fee agreements are not permitted in criminal cases. Non-contingent fees. If this is not a contingent agreement, but rather is a fee agreement, certain requirements must be met. The agreement must state how the lawyer's fee is calculated, what the duties of the clients and the lawyer are, and what expenses will be paid out of the fee. In California, the agreement is required to be in writing unless it is for 1. Less than $1,000, 2. A corporation, 3. Regularly performed services for a regular client, 4. It is impracticable, or 5. There is an emergency. Fee amount. The $10,000 flat fee under the ABA, the fees that a lawyer charges must be reasonable. Under the ABA, a lawyer's fees cannot be unconscionably high. Some factors used to determine whether a lawyer's fees are reasonable are the time he spends on the case, his expertise and experience, the difficulty and novelty of the matter, and the result obtained. Loans to clients. Under the ABA rules, a lawyer is prohibited from making loans to his client unless 1. The loan is an advance of litigation costs to an indigent client, or 2. The loan is an advance of litigation fees in a contingent case. Under the CA rules, a lawyer is allowed to make a loan to his client for any reason so long as the client and the lawyer enter into a written loan agreement. Additionally, in CA, a lawyer is prohibited from promising to pay a client's debts in order to persuade the client to agree to have the lawyer represent them. Duty of loyalty. Under the ABA and CA rules, a lawyer owes a duty of loyalty to his or her clients to zealously advocate on their behalf and be free of conflicts of interest that have a significant chance of materially affecting their ability to do so. That duty begins, at the very least, at the execution of a retainer agreement. Conflict of interest. Under ABA, CA laws, a lawyer must not represent a client if the representation is 1. Directly adverse to another client, or 2. Materially limited by responsibilities to another client, a former client, a third party, or the lawyer's own interests. Representation despite conflict. An attorney can still represent a client, notwithstanding such a conflict of interest, so long as the client consents and the lawyer reasonably believes that the conflict will not infringe on his or her ability to zealously and competently advocate on behalf of her client. While the ABA would require written consent for such a conflict, California requires only written notification by the attorney because the conflict is only personal. Withdraw. A lawyer is free to, more or less without restriction, take or not take clients and causes of action, although is encouraged to do pro bono. But once they decide to take a client, many ethical rules apply. CA and the ABA allow an attorney to withdraw from representation under certain circumstances, and require an attorney to do so under others. For example, if an attorney is not receiving their fees or other obligations pursuant to the attorney-client relationship, and they have notified the client and given the client a reasonable time to remedy the situation, then the attorney is permitted to withdraw. Additionally, attorneys may withdraw if the clients are using their legal services for illegal purposes. Moreover, if the attorney finds the representation of the individual repugnant to their sensibilities, they may withdraw so long as they do not materially harm the client's interests. If representing the client would require the attorney to violate other ethical rules or laws, then the attorney must withdraw. Thus, for example, if representing a client would require the attorney to file a frivolous lawsuit, then the attorney must withdraw. Indeed, California allows the unreasonable financial burden on the attorney as a justification for discontinuing representation of a client. Duty to communicate. Indeed, the rules allow a lawyer to withdraw from representing a client when the client fails to communicate with the lawyer. Much like a lawyer has a duty to communicate with the client, as Len effectively did here once he learned of the potential vexatious litigant problem, a client must fulfill their side of the bargain and communicate back. Much as in failures to pay attorney fees, the attorney must reasonably notify the client of the consequences of failure to and give them a chance to respond before withdrawing from representation. Court's approval to withdraw. Moreover, in California, after a lawsuit has been filed, an attorney cannot withdraw from representing a client without attaining the judge's permission to do so. Duty to the court to investigate positions. An attorney is required to investigate legal positions and pleadings taken and represented to a court before doing so. The standard for this is what a reasonable attorney would do in similar circumstances. Duty to protect evidence. A lawyer has the obligation to keep any property of the client's that is in his possession in a safe and secure location. Moreover, the lawyer certainly cannot destroy evidence that the client entrusts to him. The lawyer must take reasonable protective measures to safeguard such evidence, if the lawyer chooses to accept responsibility for possessing it. Attorney-client relationship. An attorney-client relationship is formed when the client reasonably believes the relationship formed. The attorney's beliefs are irrelevant. Within the scope of the representation, an attorney determines the means, including which claims to present and which witnesses to call, and a client determines the ends, including whether to accept a settlement offer and other duties. Duty of loyalty. An attorney owes a duty of loyalty to his clients and cannot accept representation if it would result in a conflict of interest that would materially impair his representation of client. Conflict of interest. A conflict of interest may occur between an attorney and his client, between two clients, whether former and current or two or more current clients, between a third party and client, or between the members of an organization and the organization itself. A conflict of interest may occur between the attorney and his client when the attorney has a close relationship with opposing counsel in a case. Duty of communication. An attorney must promptly and diligently communicate with his client. This duty includes a duty to inform the client of their responsibilities and obligations with respect to the representation. Duty of competence. An attorney owes a client a duty of reasonable knowledge, skill, and ability in the scope of the representation. Duty to safeguard. L owed C a duty to safeguard the evidence she gave him. An attorney owes a duty to the client to safeguard possessions of the client, including money given as a retainer, and any possessions or evidence entrusted to the attorney. Mandatory withdrawal. An attorney may withdraw if representation will necessarily cause a violation of an ethical rule. Under the ABA, this extends to any law. An attorney must also withdraw if, because of his physical or mental condition, continued representation would materially impact the client. In California, an attorney must withdraw if the client insists on pursuing a claim without probable cause and with the purpose of harassing or maliciously injuring another person. Under the ABA authorities, an attorney must withdraw if he is fired. Permissive withdrawal. An attorney is permitted to withdraw if a client insists on pursuing an illegal course of conduct. An attorney is also permitted to withdraw if they insist the attorney take actions against the attorney's judgment, violating the scope of the relationship so that the attorney is no longer dictating the means of the litigation. An attorney may also permissively withdraw if the client does not pay her fees or for any other good cause shown. An attorney is also permitted to withdraw if the client makes representation unreasonably difficult. Withdraw in CA after filing lawsuit. Additionally, in California, an attorney may not permissively withdraw if the matter is currently pending before a tribunal. Because L filed the lawsuit in state court, the matter is currently pending before a tribunal, and L must seek court permission to withdraw. Attorney-client privilege. The attorney-client privilege protects confidential communications made to facilitate legal representation. It is narrower than the duty of confidentiality, which applies to any information related to the representation of a client, even if no attorney-client relationship is formed. The attorney-client privilege protects communications made by the client or the client's agent to the lawyer or the lawyer's agents. In the corporate context, the attorney-client privilege, in California, protects communications made by a spokesman for the corporation or by someone whose actions could be imputed to the corporations for purposes of liability. The attorney-client privilege attaches and applies even if a lawyer is subsequently removed from a case. However, in California, the attorney-client privilege ends when the client dies and his estate is entirely disposed of. Consequently, here, the attorney-client relationship between Luke and Don ended when Don died, and his estate settled Claire's claim against the estate. In California court, Luke would not be able to claim attorney-client privilege. Work product. In California, the work product privilege applies solely to materials prepared by the attorney in anticipation of litigation. This is unlike the federal rules, where the work product doctrine applies generally to materials prepared in anticipation of litigation. Materials prepared in anticipation of litigation, that are comprised of the attorney's mental impressions, notes, or opinions, are absolutely protected and are not discoverable. Other materials prepared in anticipation of litigation received are qualified work product. These materials may be discoverable upon a showing of substantial need and inability to acquire the materials elsewhere. To the extent the memorandum expresses Luke's belief that Wendy would be a good witness for Claire, it is absolutely privileged. This portion of the memorandum is made up of Luke's mental impressions and opinions. The court should absolutely not compel Luke to produce this portion of the memorandum. It is worth noting that the mere presence of an absolutely protected mental impression or opinion in a document does not make the entire document or the information contained therein absolutely privileged. If the court did determine there was substantial need and unavailability, and chose to compel Luke to produce the memorandum to the extent it recounts his interview with Wendy, then it could redact or eliminate the portions of the memorandum that are absolutely privileged. Fee agreement financial duties. In California, fee agreements must be in writing unless the amount is less than $1,000, the work is for a corporation, the client agrees to forego a written agreement, the work is routine, or there is an emergency. The ABA does not have a similar requirement for non-contingent fee agreements. They do not have to be in writing, although it is encouraged. Luke's decision to tell Wendy about the fraud duty of confidentiality. The duty of confidentiality requires a lawyer not to disclose information learned in the course of representation. It attaches even when no attorney-client relationship is formed, unless there is a disclaimer in plain English, so long as the information is related to legal representation. It survives the representation and the client. Exceptions. California and ABA authorities provide exceptions to the duty of confidentiality when a client makes a claim against a lawyer, when the information relates to the services provided by the attorney, when disclosure is required by the court, and when the lawyer learns information relating to imminent death or substantial bodily injury of a third party. An attorney is also allowed to reveal information that is necessary to represent the client, or that the client consents to him revealing. The ABA permits disclosure when a client is using the lawyer's services to perpetrate fraud or commit a crime that is likely to result in substantial financial loss. It also permits disclosure when seeking an ethical opinion on a matter. California does not have an exception for financial loss. Duty of fairness, lawyer testifying. Under ABA authorities, a witness may not represent a client if he is likely to have to testify at trial. A client generally may not testify at his client's trial unless his testimony relates to his services, a breach of his duties, or his testimony is necessary to prevent undue hardship. In California, an attorney may testify at a bench trial and may testify if his client consents at a jury trial. Duty of competence. An attorney owes a duty of competence to his clients. He must have the necessary skill, thoroughness, and preparation required for competent representation. The duty requires the attorney to communicate with the client about important matters. California punishes intentional, repeated, or reckless violations of the duty of competence. Duty of loyalty. The duty of loyalty requires an attorney not to use non-public information against a client in a subsequent proceeding. According to ABA authorities, if there is a significant likelihood that an attorney will be materially limited in his representation of a client by professional or personal interest, the attorney can only take on the representation if he reasonably believes he can provide representation unaffected by the conflict, he informs the client, and he receives consent. The informed consent must be memorialized in writing. In California, there is no reasonable belief requirement. Both potential and actual conflicts require disclosure, and consent must be in writing unless it is based on an attorney's past representations or personal conflicts. Duties on withdrawal. When an attorney is fired, he must return all unspent retainer money, as well as the client's papers and documents necessary for representation. California authorities specifically prohibit holding on to client documents for the purpose of getting paid. Attorney-client privilege. In California, the attorney-client privilege attaches to a communication made in confidence between a client and his lawyer in the course of the representation. The client, the sole holder of the privilege, can bar the lawyer from testifying as to the content of the communication. However, the privilege does not survive the death of the client after the client's executor has finished distributing his estate. There are certain exceptions to the attorney-client privilege, including when the lawyer reasonably believes that disclosure would be necessary to avert serious bodily harm to others, and when the client is attempting to use the lawyer's services to perpetrate a crime or fraud. Work product doctrine. California law privileges from discovery documents produced in anticipation of litigation. It also draws a distinction between a qualified privilege, which attaches to statements of fact recounted in work product, and an absolute privilege, which attaches to statements of belief or opinion by an attorney contained in work product. The qualified privilege may be overcome by a showing that there is a substantial need for the facts contained in the work product, and that they are unavailable through other means, whereas the absolute privilege cannot be overcome. The work product doctrine survives the death of the client. Duty of confidentiality. Under the ABA and California rules, a lawyer owes his client a duty of confidentiality. This duty prohibits a lawyer from revealing to any third-party information learned from or about the client in the course of the representation, unless an exception applies. It attaches as soon as a lawyer-client relationship begins. Exceptions to the duty of confidentiality. Averting physical harm. A lawyer may reveal a client's confidential information under the ABA and California rules if he reasonably believes that disclosure is necessary to avoid imminent bodily harm to a third person. In California, the harm must arise out of a criminal act, and the lawyer must first attempt to dissuade the client and inform him of the lawyer's intent to reveal. Serious financial harm using the lawyer's services. The ABA, but not California authorities, allow disclosure if the lawyer believes it to be reasonably necessary to avoid serious financial harm to a third party, and the harm would be perpetrated using the lawyer's services. Fact has become generally known. Under both ABA and California rules, a lawyer may reveal a client's confidential information if that information is no longer confidential because it has become generally known. Safeguarding the client's property. A lawyer owes his client a duty to safeguard the client's property under both ABA and California law. This includes a duty to return to the client all materials related to the representation upon the end of representation. A lawyer may not retain a client's case file, including for the purposes of recovering his fee. Sexual relations. The ABA rules prohibit sexual relationships with clients, unless there was a pre-existing sexual relationship. The CA rules also allow for a pre-existing sexual relationship, but also allow for new sexual relationships so long as sex is not a condition for professional representation, the client is not unduly influenced or coerced into sex, and the lawyer's performance is not negatively affected by the sexual relationship. Duty of loyalty. When there is a significant risk that the interests of another client, the lawyer, or a third person could materially limit the representation of the client, there is a conflict of interest. Duty of competence. Under the ABA rules, a lawyer has a duty of competence, which is to possess the necessary skill, knowledge, preparation, and thoroughness reasonably necessary to represent the client. If the lawyer does not have the requisite competence, the lawyer must either learn the law without undue delay or expense, or associate with a lawyer who is well versed in the law, subject to client approval in bringing on this new lawyer. Under the CA rules, a lawyer has breached her duty of competence if the lawyer intentionally, recklessly, or repeatedly fails to provide competent representation. Would they be subject to discipline? Limitation of malpractice liability. Under the ABA rules, a lawyer may not limit a client's right to seek disciplinary action or to participate in an investigation. The ABA rules allow for the client and lawyer to limit malpractice liability, so long as the client is represented by independent counsel. The CA rules, however, expressly forbid any limitation of malpractice liability. Therefore, L is in breach of the ABA rules because C was not represented by an independent attorney when L's malpractice liability was limited, and is in breach of the CA rules because they do not allow for any limitation on malpractice liability. Contingency fee. A contingency fee agreement under the ABA rules must be in writing, state the percentage of fees that the lawyer would receive, what expenses would be deducted from recovery, and whether the lawyer's percentage would be deducted before or after expenses were deducted. Under the CA rules, the fee agreement must also state how other costs will be paid, as well as that the fees are negotiable. Fee in writing. The CA rules require written agreements for non-contingency fees unless the fees will be under $1,000, is for a corporate client, is for routine matters, the client agrees otherwise in a separate writing, or there is an emergency or other good reason. Duty of care. A lawyer must act in good faith and is a reasonably prudent person with the same care, skills, and caution as would be expended on her own matters. Duty of diligence. A lawyer has a duty to pursue cases to completion and to diligently represent clients in their matters. Part of this duty under the ABA rules is the duty to act promptly and expedite a client's case if it is in the client's best interest. Under the CA rules, the lawyer may not unduly delay for improper purposes or for her own convenience. Fee disputes. When there is a dispute as to the fees owed, the lawyer must send the undisputed portion to the client and is entitled to keep the disputed portion in the client trust account until the dispute has been resolved. Sexual relationship. Under the ABA model rules, ABA, it is permissible for an attorney to represent a client with whom she has a pre-existing relationship, as long as the sexual relationship will not compromise the attorney's competence or duty of loyalty to the client. However, the ABA, lawyers may not enter into sexual relationships with clients that begin after they take on the clients. In California, attorneys may carry on sexual relationships that pre-existed the lawyer-client relationship, as well as being sexual relationships during the pendency of the representation, as long as competence and loyalty are not compromised. In addition, under CA rules, an attorney cannot condition acceptance of a client on agreement to have sex with the attorney. Duty of competence. An attorney has a duty to competently represent her client, which means using the knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. However, an attorney is permitted to take a case which she might not otherwise be competent to take if she can acquire through study the skills/knowledge necessary to represent the client and/or work with another attorney who specializes in that area. Agreement not to sue for malpractice. Under ABA rules, a client can only contract away her right to sue an attorney for malpractice if the she is represented by outside counsel and agrees in writing. CA rules prohibit attorneys from contracting out of malpractice liability under any circumstances. Duty of loyalty. The duty of loyalty is always potentially implicated when a client and a lawyer have a sexual relationship. The duty of loyalty requires an attorney to avoid conflicts of interest. A conflict of interest exists when the interests of another client, a third party, or the attorney herself are adverse to materially conflict with those of the client. Representation despite conflict of interest. Under the ABA, when a conflict exists, an attorney can only represent a client if she reasonably believes she can do so competently. She discloses the conflict to the client and gets the client's consent in writing. In CA, the belief need not be reasonable, but only sincerely held, and personal conflicts only require written disclosure, not written consent. Fee agreement. Under the ABA, fee agreements must be reasonable. They don't have to be in writing, unless they are contingency agreements, in which case they must state the percentage of the attorney's fee, what expenses will be deducted, whether expenses will be deducted before the attorney's fee, and must be signed by the client. Under CA rules, all agreements over $1,000, not with corporate clients, regular clients, or under exigent circumstances must be in writing. In addition to the ABA contingency fee requirements, CA contingency fees must include in writing that attorney fees are negotiable and state how non-covered services will be paid. In addition, the entire fee must not be unconscionable. Fee dispute. When there is a dispute over fees, the lawyer must retain the disputed portion in the client trust account pending resolution of the dispute. Corporation as a client. An attorney may represent a corporation as a client. The corporation acts through its duly appointed representatives, usually officers. However, the corporation, not the officers, is the actual client, and the attorney must be careful not to provide legal information to the officers in a personal capacity, or to mislead them into believing that the attorney represents them personally. Duty of loyalty. An attorney owes his clients a duty of loyalty. The duty of loyalty includes the duty to refrain from conflicts of interest. Conflicts of interest take several forms: conflicts personal to the lawyer, conflicts between current clients, and conflicts between current and past clients. Lawyer-client conflict. A lawyer may breach his duty of loyalty by representing a client with interests adverse to his own. This often arises when litigation the attorney is handling is adverse to one of his personal interests. When an attorney has a conflict between his or her personal interests and the interests of the client, under the California rules he or she must provide the attorney with written disclosure of the interest. The model rules, by contrast, require that the attorney get informed consent from the affected client before continuing with a representation that raises a personal conflict. Further, under the model rules, the lawyer must reasonably believe that he will be able to provide competent and diligent representation in the face of the conflict. Current clients. A lawyer may breach his duty of loyalty by representing current clients whose interests are adverse to other current clients. Under the model rules, a lawyer must get informed consent from the adversely affected client and reasonably believe that they can undertake the representation in spite of the conflict. The model rules require this consent only for actual conflicts of interest. By contrast, California requires informed consent for either actual or potential conflicts of interest. However, California does not require that the attorney reasonably believe he can prove competent representation in the face of the conflict. Former clients. Like a conflict of interest arising from the representation of current conflicting clients, an attorney may likewise breach their duty of loyalty by representing a client with an interest adverse to a former client. In this case, the test under the California rules is generally whether the attorney learned any confidential information in the previous representation, which could harm the client. Duty of confidentiality/disclosure. An attorney owes a duty of confidentiality to his clients. This requires, under both sets of rules, that they keep any information related to the representation confidential and inviolate. The duty of confidentiality is not absolute, and the model rules and California rules both have exceptions for disclosure in case of fraud or financial harm, model rules, or the threat of serious bodily harm or death, both sets of rules. 2. Reporting ABC's false reports. The model rules and California rules treat the disclosure of confidential corporate information differently. When an attorney discovers that a corporation has undertaken an unlawful act, such as filing fraudulent documents or committing a criminal act, under both sets of rules an attorney must first report up. Reporting up requires that the attorney take the matter to the most senior member of the corporation. Under the model rules, if the executives of the corporation refuse to take action, the lawyer may report out if he believes it is in the best interest of the corporation. This is an exception to the duty of confidentiality and allows the lawyer to report misconduct to an outside agency. California does not permit reporting out for financial crimes. California permits reporting out only when he or she has reason to believe that I, the client, or a third party will commit an act that creates a risk of death or substantial bodily harm. 2. He or she has remonstrated the client to not take this action, and 3. The disclosure is reasonably necessary to prevent the harm. Under the California rules, a lawyer may not disclose financial harms, although he may choose to withdraw from the representation. California permits reporting outside the corporation only where there is a risk of death or substantial bodily harm. Under the model rules, he may, but is not required to disclose the fraud to an outside agency. Under the California rules, he may not disclose the fraud and would be liable for a breach of confidentiality for doing so. Duty of candor to the court. In addition to duties owed to the client, an attorney also owes a duty of candor to the court. As part of an attorney's duty of candor to the court, the lawyer owes a duty not to advance or file frivolous claims under both the California and model rules. This requires that they not knowingly put forward a claim that is unsupported by the law, although a good faith argument for modification or reversal is not considered frivolous. Duty of loyalty. A lawyer owes to their client the duty of loyalty. Under the ABA rules, the duty of loyalty requires that a lawyer not take a representation when there is a conflict of interest, unless the lawyer, 1. Reasonably believes that his ability to represent the client will not be materially limited by the conflict of interest, and 2. The lawyer discloses the conflict to the client and receives their informed consent to continue with the representation. The California rules are quite similar, except the lawyer only needs to have a good faith subjective belief that his ability to represent the client will not be materially limited by the conflict of interest, and if the conflict is a personal conflict, the lawyer only needs to provide a written disclosure of the conflict in writing to the client. However, if the conflict is not a personal conflict, the client's consent itself, and not just a confirmation of consent, must be in writing. Representation despite conflict of interest. Under the ABA model rules, Len could still represent ABC notwithstanding this conflict if 1. He reasonably believed his ability to represent ABC would not be materially limited by this conflict, and 2. Len obtained ABC's informed consent in writing. Duty of competence. The duty of competence requires that a lawyer pursue a representation with the knowledge, skill, prudence, and effort that is reasonably required for the representation. Under the California rules, the lawyer only violates his duty of competence if he intentionally, recklessly, or repeatedly commits ethical violations. Duty to avoid filing frivolous lawsuits with the court. A lawyer has a duty to the courts and the judicial system to refrain from filing frivolous lawsuits with the court. A lawsuit is frivolous if the suit as filed was not warranted by the current law, or by a good faith argument for a change in the law. Duty to protect the interests of the corporate client. When the lawyer represents a corporate client, the lawyer owes a duty to act in the corporate client's best interests. The duty to corporate clients provides that if the lawyer learns that the corporation, or one of its agents or employees, were to commit an act of wrongdoing or other act that would be harmful to the corporation's interests or be imputed to the corporation to expose it to liability, the lawyer has a duty to report such information to the highest authority in the corporation, such as the corporation's CEO or head of counsel. If such reporting is not possible, or would not be effective at preventing the harm, under the ABA model rules, the lawyer may report the information to an outside authority to avoid harm to the corporation. In California, however, although internal reporting is still required, reporting to an outside organization is not permitted except when necessary to comply with the requirements of the Sarbanes-Oxley Act. Duty of confidentiality. A lawyer owes to his clients a duty of confidentiality. The duty of confidentiality requires that a lawyer may not disclose or reveal any information that the lawyer receives as part of the representation. The duty of confidentiality continues even after the representation has ended and even after the death of the client. Under the ABA model rules, the lawyer is permitted to reveal confidential information from the client in the following circumstances: 1. Where necessary to avoid serious bodily injury or death to others. 2. Where necessary to avoid or ameliorate financial injury to others that was a result of crime or fraud that was accomplished with the lawyer's services. 3. Where reasonably necessary to further the representation. And 4. Where reasonably necessary to comply with other ethics obligations, such as the disclosure of limited client information for conflicts checks. In California, however, the lawyer is only permitted to disclose confidential information to avoid physical injury or death to others, and if reasonable, before disclosure, the lawyer must first, 1. Reason with the client and attempt to persuade him not to follow through with his acts, and 2. Tell the client of his intent to disclose. Duty of loyalty. Under both the ABA and CA rules, an attorney must always act in good faith and in the best interest of the client. Conflict of interest. An attorney may not represent a client where the attorney's representation creates either a possible or actual conflict of interest. Under the ABA, an attorney may represent a client if the attorney reasonably believes he will be able to represent the client without a conflict and the client provides informed written consent. In California, there is no reasonableness standard, but the attorney must receive informed written consent in the case of a possible conflict and again if the conflict ripens into an actual conflict. Business deal with the client. When entering into a business deal with the client, the deal must meet 4 specified criteria. First, the deal must be on objectively fair terms to the client. Second, all terms of the deal must be clearly and thoroughly disclosed in writing to the client. Third, the client must be advised that outside counsel is recommended. Fourth, the client must provide written consent. Duty of competence. An attorney has a duty of competence in his representation of a client. An attorney must exercise reasonable skill while representing the client. Reasonable skill is determined by a number of factors, including how long the attorney has practiced, the attorney's expertise, the amount of time the attorney put into becoming informed, and the ability to associate with more knowledgeable counsel. California requires a repeated, reckless, or intentional failure to exercise reasonable skill in order to be subject to discipline. Trial publicity. A lawyer has a duty not to make any statements that she should reasonably expect to be publicly disseminated, and that are substantially likely to prejudice a judicial proceeding. A prosecutor in particular must not broadcast, or allow to be broadcast a statement that expresses an opinion regarding the guilt or innocence of a criminal defendant. If a prosecutor knows that an attorney or law enforcement agent under her oversight plans to make such a statement, the prosecutor must make reasonable efforts to prevent the statement from being issued. For instance, a prosecutor generally may announce the name of a criminal defendant, the fact of an arrest, and the nature of the charges. Prosecution despite lack of probable cause. A prosecutor's duty to seek justice requires that she never pursue a charge that she knows is unsupported by probable cause. Probable cause exists when the facts known to the prosecutor are sufficient to allow a person of reasonable prudence and caution in the prosecutor's position to seriously entertain the possibility that the defendant is guilty of the crime charged. Lack of candor before the tribunal. A lawyer's duties to uphold the integrity of the profession and to avoid prejudicing the administration of justice require that she make no false statements to a court in the course of a proceeding. This duty applies to prosecutors as well as to all other lawyers. Exculpatory evidence. The Due Process Clause of the United States Constitution imposes a duty on every prosecutor to disclose to the defense material evidence favorable on the issues of guilt or punishment. Evidence is material if the prosecutor's timely disclosure raises a reasonable possibility that the outcome of the trial would be different than if the evidence had been withheld. The duty to disclose exists even if the defense makes no discovery requests. A prosecutor is responsible for violating this duty even if she did not act in bad faith. Improper ex parte contact with the presiding judge. A lawyer's duty of fair play to her opposing counsel requires that she not engage in any ex parte contact with a judge in order to influence the outcome of a proceeding. There is no indication that she announced to Dave's counsel that she intended to make this contact, or that she invited Dave to speak with the judge at the same time. This was an improper ex parte contact. Moreover, it was likely intended to influence the judge in the proceedings. Attorney work product doctrine. An attorney's work product of their thoughts, opinions, legal conclusions, labor or investigation by an agent falls under privileged information and is not discoverable by opposing counsel. However, when an attorney can show I, a substantial need for the information or document, and 2, an undue hardship, such as excessive costs and inability to reproduce the same document, the court may grant an exception this rule. In California, the attorney needs to show a reasonable and compelling reason for the need to disclose the evidence. However, the information must be redacted, blacked out, crossed out, of any conclusions, opinions, thoughts about the case made by the attorney to whom the document belongs. This ensures the attorney's thoughts and any privileged information between themselves and a client remains undisclosed to the opposing counsel. Patty will argue the federal agency report is attorney work product doctrine, and thus cannot not be turned over to Dave's attorney because of privilege. However, it is likely Dave's attorney can show undue hardship without the production of the federal agency report, and thus Patty must turn over the report, or will be in violation. Scope of representation. A client usually determines the ends, goals, of a representation, whereas the lawyer generally determines the means, legal strategies. If a client is insisting upon actions that the lawyer does not wish to take, the lawyer may limit the scope of employment through informed written consent by the client. Fairness to opposing counsel/adverse parties. A lawyer should treat opposing counsel and adverse parties fairly during the representation. A lawyer should not engage in certain actions if it is known to be for the purpose of harassing or making a task unduly burdensome for opposing counsel/adverse party. Duty of diligence. That being said, a lawyer does owe a duty to her client to diligently dispose of the case, work productively, and not delay unnecessarily. If for some reason the extension requested was unreasonable, or it had been one of many requests for extensions, then perhaps Alice would be justified in denying the request. She has a duty to her client to make sure that his case is handled efficiently and effectively. Duty of candor. A lawyer owes a duty of candor to opposing counsel, adverse parties, and the court. A lawyer must not submit evidence that she knows to be false, or make a false statement of fact or law that she knows to be untrue. If she makes such a statement without knowing it is false and later learns of its true nature, the lawyer has a duty to correct the evidence or testimony. Duty of confidentiality. A lawyer owes a duty of confidentiality to her client for anything related to the representation, even if not made by the client. Under the ABA, a lawyer may reveal confidences if the client persists in engaging in criminal or fraudulent conduct that will result in death or serious bodily harm, or if the lawyer's services are being used to perpetuate a crime or fraud by client that will result in serious financial harm. California does not have an exception for financial losses. Duty of loyalty. A lawyer owes a duty of loyalty to her client. If the interests of another client, the lawyer, or a third party materially limit the lawyer's ability to effectively represent the client, then she has a conflict of interest. The lawyer must act in the best interest of the client. An attorney owes a duty of fairness to his opponent. In this case, Abel owes a duty of fairness to Barbara, landlord's attorney. An attorney may not communicate with the opposing party or its employees without the opposing party's attorney's consent or presence. While it may be permissible for an attorney to communicate with low-level employees, communication with a high-level employee requires the opposing party's attorney's consent. Duty of confidentiality. An attorney owes a duty of confidentiality to his client. Under the ABA Model Rules, ABA, an attorney may not disclose anything related to the representation without the client's consent. California does not have such a rule, but the attorney's oath requires a lawyer to maintain inviolate the secrets of his client. Exceptions. There are some exceptions where a lawyer is permitted to reveal confidential information, such as where a dispute arises between the lawyer and the client, which allows the lawyer to reveal confidential information to the extent necessary to defend himself, or under the ABA and CA, where disclosure of confidential information is necessary to prevent certain death or risk of substantial bodily injury, or under the ABA, where disclosure is necessary to prevent or mitigate fraud or substantial financial loss where the lawyer's services were used in furthering the fraud or financial injury. Duty of honesty and candor to tribunal and adversary. A lawyer owes the court and his adversary a duty of candor, fairness, and honesty. A lawyer cannot knowingly offer a false statement of law or fact to the court, and upon learning of the falsity, the lawyer owes a duty to the court to correct the false statement. Duty of competence. A lawyer has a duty to competently represent his client. A lawyer must use the knowledge, skill, thoroughness, and preparation required to do so. Included in the duty of competence is a duty to communicate with the client. Duty to communicate. A lawyer owes his client a duty to communicate by informing his client of all developments in the case and by informing his client of all settlement offers. The lawyer is free to make tactical decisions, such as trial strategy, but the client must make all decisions about the case, including whether or not to accept a settlement offer. A lawyer cannot accept a settlement offer without his client's approval and consent. Duty of diligence. A lawyer owes a client a duty to diligently see the case to completion and zealously advocate for the client. Lawyer/client relationship. A lawyer owes duties to his client as soon as the relationship is formed. The relationship is formed even if the client never retains the lawyer, but approaches him regarding legal representation. Duty of competence. Under ABA and CA, a lawyer, L, owes his client the duty of competence, which requires using the requisite skill, preparation, thoroughness, and knowledge to adequately represent his client's interests. If an L is not competent in an area of law, he must become competent without undue expense or delay upon the client, otherwise, he should associate with an L who is competent in that area. Duty of confidentiality. ABA, a lawyer has the duty to maintain all confidential communications acquired in the course of representation. In CA, there is no delineated duty of communication, however, the attorney's oath requires lawyers to maintain the client's secrets and confidences. Exceptions to duty of confidentiality, consent. If a client consents, a lawyer may reveal her confidences. Duty of communication. A lawyer has the duty to communicate with his client regarding all stages of representation, to return phone calls and inquiries promptly, and to communicate the ultimate strategy decisions to the client for her decision. Referrals and referral fees. Under the ABA and CA, a lawyer may refer a client to another lawyer with the informed consent of the client, and as long as the referral agreement is non-exclusive. Under the ABA, referral fees are prohibited. Under CA, they are permitted as long as the client gives informed consent and the total fees are not increased due to the referral agreement. Duty of fairness. A lawyer owes the duty to the legal profession to maintain the public confidence, dignity, and efficiency of the legal system and the profession. Additionally, even those actions by an attorney that are not specifically prohibited by the ABA or CA professional conduct rules or the law may still be prohibited if they reflect poorly on the profession. Solicitation out-of-court statements regarding a case. A lawyer may not make public statements that are substantially likely to materially prejudice the case. He may comment on those topics that are generally public knowledge, who the parties are, what the cause of action is, and he may conduct damage control if his client has been prejudiced. Meeting with unrepresented persons. A lawyer, if meeting with a person who is not represented by an attorney, must not make any indications that he represents that person's interests or is impartial. Improperly influencing a witness. A lawyer may not pay a witness for their testimony. If it is an expert witness, the expert witness's expenses for travel and time away from work may be paid for. Contingency fee arrangement. A valid contingency fee agreement must be in writing, signed by the client, include the lawyer's percentage, the expenses to be deducted, and whether the lawyer's percentage will be paid prior to or after the expenses are deducted from the award. In California, the agreement must also include a statement as to how services not provided for under the contingency fee agreement will be provided, and that the lawyer's percentage is negotiable. Fee splitting with Tom. An attorney may split fees with other attorneys outside of his firm, subject to certain restrictions. Under the ABA, the total fee must be reasonable. Under California law, the fee may not be unconscionably high. Further, the client must be informed about the fee splitting and must consent to it. Finally, the fee must be split proportionately in accordance with the relative amount of work that each attorney performs. Advertising. Attorney advertising must abide by certain rules. An attorney cannot engage in real-time phone or live contact with prospective clients with whom he has no prior personal or business relationship. Any advertising must be labeled attorney advertising, it cannot make any misrepresentations or be misleading, and it must state the name of at least one attorney responsible for the material. In California, making any guarantees or warranties as to results is considered presumptively improper and constitutes a misrepresentation. Advertising. Both the ABA and California prohibit in-person, live solicitation to individuals who the attorney does not have a familial or professional relationship with. However, attorneys are allowed to send professional announcements, letters, cards, etc. to people in the area. Moreover, the document must have certain information contained in it, such as the attorney's name, or if it is a firm, a name of one attorney in the firm. It must also have an address listed for the attorney, and/or any other relatable contact information. However, the document must be accurate and fair. The attorney is not allowed to guarantee success rates or hold himself out as a specialist unless he is certified by the proper authorities in the state. Paying an expert witness fee. Both the ABA and California rules permit attorneys to compensate expert witnesses for their time exerted on the case. However, the compensation cannot be hinged on favorable testimony from the witness. The compensation must also be reasonable in light of factors such as the expert's familiarity with the subject, his experience in the field, and other similar factors. False testimony by witness. Under the ABA, an attorney shall not call a witness to testify if the attorney knows the witness will commit perjury. However, if the witness is the defendant in a criminal case, he has a constitutional right to testify on behalf of himself. The ABA states that if her client insists on testifying and perjuring herself, the attorney must attempt to persuade her not to. If the client still insists on testifying, then the attorney should attempt to withdraw as counsel if the court will allow it, depending on how damaging it will be to the client. Finally, if the attorney is unable to withdraw, he must carefully weigh the balance of his duty of confidentiality with his duty of candor to the court. If the client persists on testifying, then the attorney may advise the court about the perjury. The big distinction is that in California, an attorney is allowed to let his client testify in narrative fashion regarding the false information. He also is not required to breach his duty of confidentiality and warn the court of the perjury. Sending the doctor a gift. Both the ABA and the California rules prohibit sending gifts to witnesses who testify on their behalf. The attorney is only allowed to compensate the expert witness for her services in the case, such as depositions, preparing for trial, and testifying. Moreover, a gift to an expert witness may compromise the witness's ability to be fair and not to give favorable testimony in anticipation of a gift. If the gift was intended for the doctor as a thank you for testifying, it will not be allowed. Solicitation. As noted, the ABA and California rules of professional conduct prohibit attorneys from soliciting clients for pecuniary gain in person or over the phone. There is an exception where the client and the attorney have an established relationship, are family members, or the client is a corporation. Duty of candor. In contrast, all attorneys also have a duty of candor to the court. This means that attorneys should not offer false evidence into the record. Where there is authority that is controlling and on point, the attorney must bring such authority to the court's attention, even if the authority is detrimental to the attorney's position. Attorneys must conduct themselves honestly in court and may not make any malicious, unfounded claims that the attorney knows have no support in the record. Sharing fees with non-attorneys. Under the ABA rules, an attorney may not share legal fees with a non-attorney. In California, the attorney may share a fee if the attorney discloses the fee-sharing arrangement to the client, and the client consents. Paying for referrals. Under the ABA ethical rules, attorneys may not offer money or services in exchange for getting referrals for prospective clients for pecuniary gain. However, in California, the attorney may pay for a referral if the attorney discloses the referral to the client at the outset of contacting the client, and the client consents to the representation despite having this knowledge. Entering into business transactions with clients. An attorney can only enter a business transaction with a client if 1. The terms are fair and reasonable, 2. The terms are communicated to the client in an easily understandable manner, 3. The client is advised to get independent counsel to represent him in the transaction and is given a chance to do so, and 4. The client consents. Fees. Under the ABA, a fee must be reasonable. In CA, fees can't be unconscionable. Further, in CA, a fee agreement must be in writing unless it's 1. Less than $1,000, 2. With a corporation, or 3. For a routine matter involving an existing client. Duty of loyalty. Under both the ABA rules and the California rules, an attorney has a duty of loyalty to her client. This duty includes an obligation to avoid conflicts of interest between current and former clients, clients and third parties, clients and the attorney herself, and organizational conflicts when representing an entity such as a corporation. Actual conflict. First, an attorney cannot represent a client when one of her personal interests materially conflicts with an interest of the client in a way that could impair the attorney's representation of the client. However, if the attorney reasonably believes, that is, subjectively believes in an objectively reasonable way that she can diligently and competently represent the interests of the client, she can still represent the client as long as she discloses the issue and receives informed consent. Under the ABA, informed consent may be oral and confirmed in writing, while under the California rules there must be written informed consent. Potential conflict. If the attorney has a close personal relationship with opposing counsel, such as a familial relationship or close friendship, the attorney must disclose that potential conflict to the client. As with the general rule, in order to press forward with the representation, the attorney must reasonably believe that she can adequately represent the interests of the client. Under the ABA, the attorney must receive informed consent, while under the California rules the attorney must provide the client with a written disclosure of her relationship to opposing counsel. Candor to the tribunal. Under both the ABA rules and the Candor rules, an attorney owes a duty of candor to the tribunal. This means that an attorney may not knowingly offer false evidence and must correct any material misstatements or misrepresentations on the record. While an attorney may offer evidence to the tribunal if they worry, but are not certain, that the evidence may be false, in general an attorney should strive to represent their clients with candor and honesty to the court. That said, an attorney must balance this obligation against a duty to zealously represent the interests of their client within the ethical bounds of the law. Duty of fairness. Under both the ABA rules and the California rules, an attorney owes a duty of fairness to opposing counsel. This means that the attorney may not suppress evidence she is required to disclose, and ought not to lie to opposing counsel, or make dishonest representations to opposing counsel with the goal of misleading opposing counsel. Duty to avoid frivolous claims. Under the ABA rules, an attorney ought not press a claim or argument unless there is a good faith basis in the law or a good faith argument for extending or changing the law in support of the claim or argument. In contrast, under the California rules an attorney must not press a claim when she lacks probable cause for the claim and has a purpose of harassment for pressing the claim. Part of this duty is investigating claims to ensure that they have a proper foundation under the law. Duty of competence. Under both the ABA rules and California rules, all attorneys have a duty of competence to their clients. This includes having the relevant skills, knowledge, and preparation to adequately represent the client. In California, this also includes having the relevant mental and physical capacity, and an attorney must not recklessly, intentionally, grossly negligent, or repeatedly violate this duty. Scope of representation. Under both the ABA rules and California rules, an attorney must follow the bounds of the scope of representation. Some issues are solely up to the discretion of the client, including whether to accept a settlement offer, whether to testify, and whether to waive a jury trial right. The client also has full control over the goals and ends of the representation. However, the attorney has control over the means of representation, subject to a duty to consult with the client and communicate with the client about the means of the representation. Duty of communication. Under both the ABA rules and the California rules, an attorney has a duty to communicate with the client. This includes keeping the client apprised of any developments in the case, letting them know about written settlement offers or other major settlement offers, and generally consulting with the client and keeping in regular contact. Duty involving leverage in a civil case. Under the California rules, an attorney must not threaten criminal or disciplinary action in order to obtain an advantage or leverage in a civil case. Duty to tattle on opposing counsel. Under the ABA rules, if an attorney has actual knowledge that another attorney has violated the ethical rules or has taken some action that materially reflects poorly on their fitness as an attorney, they must disclose these facts to the State Bar Association or other ethical authority. In contrast, the California rules do not have a similar provision except that an attorney must disclose certain issues related to their own ethical standing. Mandatory withdrawal. Under the ABA and California rules, an attorney must withdraw from representation in a few circumstances. First, an attorney must withdraw from representation if their health impairs their ability to represent the client. Under the California rules, that impairment must make the representation unreasonably difficult, while under the ABA rules it must materially impair the attorney's ability to represent the client. Second, an attorney must withdraw from representation if the representation would necessarily lead to or facilitate a crime or fraud. Third, an attorney must withdraw from representation if the representation would violate an ethical rule in California or would violate an ethical rule, a civil law, or a criminal law under the ABA. Fourth, an attorney must withdraw if they are fired by the client. Finally, an attorney must withdraw if the client is asking them to press a frivolous claim, under the definitions provided above, example, probable cause and harassment in California, or lack of good faith under the ABA. Permissive withdrawal. Additionally, there are circumstances where an attorney may withdraw from representation permissively. These include when the client materially violates the retainer agreement, and the attorney provides a warning that they will withdraw if the client does not cease their violation, lesser forms of crime or fraud such as if the client is seeking to commit a crime or fraud in the future, or if the client is trying to force the attorney to engage in a crime or fraud, if the attorney's health impairs the representation to a lesser degree, if there is good cause shown, if representing the client has become unreasonably difficult, including under the ABA if the client and attorney have a fundamental disagreement, and for a variety of other reasons. Under the ABA, an attorney can withdraw for financial reasons, or for any reason that won't materially harm the client, and under the California rules an attorney can withdraw if they have a serious disagreement with co-counsel such that withdrawing is in the best interest of the client, or if the client wants to press an unwarranted claim or argument. Steps after withdrawal. After withdrawing from representation, an attorney must take 4 steps under both the ABA rules and the California rules. First, an attorney must return any unearned fees, although in California they may retain any true retainer fees or referral fees. Second, an attorney must return all of the client's personal property and papers, which they must have carefully safeguarded in the meantime. Third, an attorney must mitigate any potential harm to the client. Finally, an attorney must give the client proper notice and a reasonable amount of time to find new counsel. Further, during ongoing litigation, an attorney must seek leave from the court before withdrawing. If the court denies the request, then the attorney must continue to zealously represent the client.